Yay, we are live. We are live. Let me just start by sharing my screen. Window presentation. Share. But I also want to see myself. Okay, I can't. I want to see if you guys are here. Everything that could go wrong actually went wrong. And I'm so sorry for the delay. But we are back live now. Tell your friends to tell their friends to tell their friends to tell candidate attorneys. Wake them up and let them know that I am live and I'm about to start right now. If you can hear me, please just type in the chat box that you can hear me so that I can start. If you can see me, if you can hear me, please let me know. Yo, issues with this live were a lot. We are back now. I just want to know if everybody can see me, if people can hear me, and then we can just start with the session. All right, share this link to your friends, their other friends, and we can just start. I'll be starting very soon. So if you can hear me, please just write in the chat box that we can hear you, and then I'll start. Can you hear me? Am I audible? All right, I'm going to start now. If you can hear me, please just type in the chat box that you can hear me. If you can see and hear, please just let me know so I can begin. Okay, I am audible and you can see me. All right. Good morning to you all candidate attorneys. Thank you so much for joining my revision session. I am excited for this session. I'm super excited because I know that preparing for board exams can be quite stressful. So I just prepared this little revision session to just put you at ease and just give you some pointers as well as content that you need to know for paper 3. My name is Shella, or you can call me your legal bestie, and I am an admitted attorney of the High Court of South Africa. There is my email address if you need to email me if you have any questions regarding anything really. Just pop me an email and I'll get back to you as soon as I possibly can. However, I prefer that you comment your questions. You leave your you leave your questions in the comment section is what I'm trying to say. I prefer you do that so that other people can benefit from the answer as well. I've seen that sometimes people ask questions and you know they'll ask me privately, but I'm like, it would have benefited other people if it was in the comment section. And sometimes you ask something in the comment section and you find that a whole lot of people also wanted to ask that question. People will like that question because they also had the same question. So I think if you leave your question in the comment section, it will be easier for everyone and everyone can just benefit from that. And also, other people can also give their response. Sometimes I might give a response and somebody else might actually have something to add to it. So I think just leave your comment in the comment section, leave your question in the comment section. It will be better that way. But if you're not comfortable with that, you can pop me an email. And then obviously my YouTube channel is Shella, your lawyer bestie. You are on the channel, so you already know what's up. Now let's start. The structure of this presentation is as follows. Every topic will be discussed in accordance to how it was asked in the past papers. And then past papers that will be used are from 2019 to 2013. Please download the past papers from the LEAD website. I think download the past papers before we start. You can pause this video and just download the past papers so that you can follow along as I go with the session. So get the past papers, and then this live session will be uploaded on YouTube so that you can watch the replay as many times as needed. The reason for that is that I believe that repetition is key for good memory. If you want to remember something, you need to see it, hear it, or do it repeatedly in order to fully grasp it. So even the session here on YouTube will enable you to go over this session as many times as you need to, so that remembering certain things and concepts can be a lot easier for you. And then I recommend that you watch the video Tips for Passing Paper 3. This is the thumbnail for it. I recommend that you watch this video because the tips that I share in that video, I will not be repeating them on this live because I don't want to waste time. I also don't want this live to be long because I want you to watch this live again, pause it, go over certain topics again. And if the live is too long, it becomes so boring to watch because you're like, oh, 2 hours of watching a live, that's a long time for me. Having to watch something for 2 hours again, being on a live and then having to watch it again is quite difficult because it's too long. But if the live is short, it'll be easier for you to watch. And also, if you watch this and this live, if you watch this video plus the live, everything will be much better. Everything will just make sense for you. Does that make sense to everybody? Okay, let me see. All right, everybody can see me, everybody can hear me. Perfect. So, yes, watch the tips and then the live because I will not be repeating the tips here. And then general tips and advice is don't just study to pass. When you are studying for this paper, as you are preparing, I want you to know that the knowledge that you acquire while studying for this paper is the knowledge that you're going to use in practice as an attorney. Whether you are a practicing or a non-practicing attorney, ethics are something that you need to know. There's no two ways about it. You need to be ethical, whether you are practicing or non-practicing. The next one is that divide your work into sections while you are studying. I am not a huge fan of consolidating work and studying things from front to back. That doesn't make sense because when you divide your work, you will see that it'll be easier for you to monitor how much of each section you know. I explained all this in detail in the video that I recommended, but I just wanted to point this out that don't consolidate your work. Sectioning out your work makes it easier for you to track the content you've covered, and it just makes it easier for you to remember because you get to study and focus on one specific section until you grasp it and then you move on to the next one, as opposed to just mixing everything and going about, you know, front to back. You might miss certain things, or you might not even know how much of a specific section you've covered already. And then the next point is that knowing the theory is what makes for great drafting. There's no other tip when it comes to drafting except knowing the theory behind the drafting. For example, when you write paper one, right? If you don't know what Rule 18 says, and Rule 18 is the rules relating to pleadings in general, if you don't know what the rules say, you won't know what a pleading is supposed to look like. Like, for example, one of the things that the rule says is that a pleading needs to be divided into paragraphs. So if you don't know that pleadings need to be divided into paragraphs and you write one big paragraph and it's looking like a letter, that is not a pleading. It shows that you don't know the theory behind the pleading. So knowing the theory is really what makes for great drafting. For example, in this paper, for paper 3, if you do not know the domicilium paragraph or the domicilium clause in a contract, if you just cram it and you've got your keywords and you've crammed that paragraph, you get to the exam and you actually forget the keywords that will enable you to remember that clause. If you forget that and you don't actually know what the reason for the domicilium paragraph is and why it's there, you won't be able to draft the paragraph because you've forgotten all your keywords. So it is easier if you know the theory behind it, so that even if you forget the clause word for word as you've studied it, but if you know what's supposed to be a domicilium, what is required in that specific clause, you'll be able to draft it much, much better. And then the next tip is that read the questions carefully in the exam. Don't rush through the questions. Don't skim through the questions. Read the questions carefully. And then the next tip is that repetition enhances memory. So go over things repeatedly. Watch this live repeatedly, as many times as you need to. Go over the work repeatedly. There's something about repeating that enhances memory. And the next one also buttresses on the previous point, and that is practice. Practice as much as you can. I highly recommend that from today until the day you write the exam, that you practice every single day from now until you write. Let a day not go by without you having practiced something relating to passing the exam. Because this is what I believe. I believe that if you reach for, how does that saying go? Reach for the stars, so if you fall, you land on a cloud. So that means aim for 100%. While you are preparing, aim to get 100% in the exam. That way, if you fall, you will land on 80, you will land on 70, you won't land on a fail. If you prepare to get 100, you cannot land on a fail. So reach for the stars. If you fall, you will land on a cloud. All right, now we are moving on to the content of the session. And the first thing that I want to talk about is a fit and proper person. So far, is everyone with me? Before we move on to the big stuff, is everybody with me? Can people hear me? Do you understand what I have just said? All right, from the live chat, it looks like everybody is on the same page. Everyone is good. All right, tell your friends to tell their friends to tell their friends, because we have officially started. So Fit and proper person. This question was asked in August 2019. It was also asked in October 2021. But essentially, it was asked as, defining what fit and proper means. So if you know the definition for fit and proper, you would have gotten those questions correctly. And it refers to meeting the characteristics of honesty, integrity, and reliability. Legal professionals ought to refrain from conduct that is illegal, fraudulent, and dishonest. The duties of an attorney. So this was not asked in any of the exams as you having to list the duties of an attorney. No. However, there are certain points that you will see that, for example, confidentiality is a whole topic on its own. Obeying client's instruction, it's a whole topic on its own. Overcharging, overreaching, and touting is another topic of its own. So I just thought that I'd put this here so it makes more sense for you as we go further into this session. And the duties of an attorney are to obey client's instruction. Now, I just want to pause and speak about this one a little bit. You need to obey the instructions of your client. As an attorney, it is your duty to advise your client as to the best way possible of going about anything. And if your client consistently persists in going the wrong direction and giving you instructions that are unlawful or illegal, you're able to terminate your mandate. But in general, you need to obey your client's instruction. But if you see that the instruction of your client is illegal, it's unlawful, then you can terminate the mandate. So you obey your client's instruction, and there's also a duty of confidentiality, reliability, and honesty towards the client. There's a duty to uphold the law, to deliver the best service possible to the client. This also includes not letting matters prescribe. So when you are offering the best possible service, that means that you are staying on top of your game. You are constantly checking for updates and developments in the client's matter, and you constantly keep them updated of what's going on in the matter. Updating clients is such a big thing. If you are a candidate attorney, or no, not if you are a candidate attorney, you are a candidate attorney. Or, maybe you have finished that, but you know what it's like to be a candidate attorney. And you know that updating clients is a big deal. You need to update clients because clients need to know constantly what is going on their matter. And this also falls under delivering the best service possible. And then the next duty is don't overcharge, overreach, or tout. That will also be explained further in this presentation. And then the next one is being true to the state. So far, is everyone with me? Are we clear on the duties of attorneys? Are we good? All right, conflict of interest. This was asked quite a number of times in the exam. It was asked in August 2019, November 2020, October 2021, August 2022. That's quite a lot. And a conflict of interest is anything which is likely to affect the attorney's judgment negatively when representing or advising a client. So this question was asked around the lines of, can an attorney represent two people, both parties to a dispute? And this depends. So if an attorney has consulted with both parties to a dispute, he runs the risk of having a conflict of interest. The general rule is that an attorney cannot represent both parties in a dispute. So that's the general rule. As an attorney, you cannot represent both parties in a dispute. However, there are exceptions to that. In divorce matters, if the dispute related to the joint estate, excuse me, In divorce matters, if the dispute relating to the joint estate are of such a nature that the involvement of the attorney has not been compromised, he may continue to act for both parties by mediating and attempting settlement. So where there is settlement, there won't be conflict of interest because the parties are not at loggerheads. And then, if the knowledge is such that the attorney's honesty, impartiality, and independence is compromised, he must withdraw as attorney for both parties. So, where there is a conflict of interest as an attorney, you are allowed to terminate the mandate. If a conflict of interest arises, you can terminate the mandate. Or if a client comes to you with a matter and upon going through the papers, or consulting with the client, and you see that a potential conflict of interest might arise, it is your duty as an attorney not to accept the mandate. So conflict of interest is quite big. As an attorney, your judgment needs to be impartial. You can't be swayed. That's why where there is conflict of interest, or you foresee that conflict of interest will arise, you need to remove yourself from that situation so that you do not breach the codes of practice. Are we together? Are we together? Are we still good? Okay, let's move on to the next one, and that is mandate. So that was asked quite a number of times. I was surprised to see how many times this question appeared. Like it was in August 2023, March 2023, October 2021, like I have listed here. And, with a mandate, you can refuse a mandate as an attorney, or you can terminate a mandate. So if client comes to you and they want you to represent them, you can refuse that mandate. So refusal of a mandate only happens if the person who has come to you is not yet your client. You and this person have not come into a mandate agreement. You have not signed a mandate agreement. So to say, you're not their attorney yet. You can refuse a mandate on the following grounds. If you don't have the necessary expertise, if, for example, somebody comes with a property law matter and all you know is family law, you can decline that mandate. If you do not have the time, you need to decline the mandate because, like I said previously, you need to offer the best service possible to your client. So if you don't have the necessary time, if you are swamped with work and you cannot, like you possibly cannot fit in this mandate, you need to decline it because then you will not be able to, be the best possible legal representative to your client. And then the next one is conflict of interest. If there's conflict of interest, you refuse the mandate. If you cannot agree on fees, if you and the potential client cannot come to an agreement when it comes to your fees, you just cannot agree on that, you can refuse the mandate. And then also if the instructions are unlawful or illegal. And then termination of mandate happens when this person is already your client. They are already your client, but during the course of you working together, this is what arises based on these grounds. You can terminate the mandate. And that is where there is illegal instructions. You can terminate the mandate. And then client failing to give further instructions. This actually happens quite a lot where a client comes to you and let's say it's a divorce matter. They give you all the information that is required and you proceed to issue summons and the defendant defends the matter, and then you tell the client and you let the client know and you want to consult with the client so you can draft the plea, and the client is like, okay, I'll let you know, I'll come back to you. And a month goes by, 2 months go by, 2.5 months, 3 months, the client is not giving you further instructions on the matter. Now you don't know, should I close this file? Like, how long should I wait? That limbo. You can, terminate the mandate and just remove yourself from that if client fails to give you further instructions. And then the next one is improper conduct of the client. and then illness of the attorney, and the last one is personality clash. That is a ground for you to terminate a mandate. The next one is legal terminology or legal cost. You need to know this. This is important. This is important. So, pro amico. Acting pro amico means that you're acting for a friend or a relative without charging fees. However, there must be a genuine friendship or relationship between you and this person that you are acting for to avoid suspicions of touting. So the relationship must be genuine. And also, acting for people in the profession falls under pro amico. So, yeah, that is acting pro amico. And then pro bono. So the full name for it is pro bono publico, and it's literally Latin for the public good. And that is where the attorney acts voluntarily without payment. So you know that when you act voluntarily without payment, you take on someone's matter, and you might start with the matter and complete it, or maybe you find the matter halfway and you take it over and you complete it without wanting payment from the client. And then the next one is costs. Costs de bonus propries. This is every attorney's nightmare. You do not want this cost against you. And that means straight from the pocket. And it means straight from your pocket as the attorney. This is where the court orders an attorney to pay on a party and party or attorney and client basis as a mark of displeasure with the conduct of the attorney. So this is where the attorney has done something that the court is not pleased with. Therefore, the court awards a cost order, and now the attorney has to pay straight from their own pocket. So you see that as an attorney, you need to act in an ethical manner to avoid things such as cost to bonis propries. And it's not just a theoretical thing, it's actually a practical thing. These costs are granted against attorneys. So that's why it is important to know the ethics in this profession so that you're able to act ethically. The next one is party and party costs. These are costs incurred in legal proceedings. It's not all the costs incurred, but only those charges and expenses that appear to the taxing master to have been necessary for the attainment of justice. And then attorney and own client. This is remuneration that an attorney is entitled to in terms of an agreement or mandate with the client. So, you guys, if I am going a little too fast, this is why I'm leaving this, on YouTube so that you can play it back, maybe play it back at a slower speed, pause, take notes, and all of that. So if I'm going a little too fast, just rewind. That's why I'm leaving this on YouTube. I know what it's like attending a class and the tutor is just flying through the notes. And before you can even like write down what it is they're saying or what's written on the screen, they move on to the next thing, and you didn't record the session, and you now face, that whole thing of feeling like you didn't even attend the class. So I'm going to leave this on YouTube so you can just play it back as many times as you have to, pause, write note, go over it, yeah. And then let's move on to the next thing. And the next thing is privilege. Privilege. It's a rule that an attorney may not disclose without the consent of a client, the client's information given to him for purposes of legal advice or representation. So this was authored in 2023, 2021 October, August 2019. So I put these exam dates so that you can refer to the specific question and then come back and look at the answer. And then, like I said, about studying things topically, I think this will help you as well. So, yeah, it is going to help you big time because you know which questions to go for when you're studying this specific topic, you know which questions to look at and how the questions are asked. So, like I said, this is a rule that an attorney may not disclose without the consent of the client's information given to him for purposes of legal representation. But it's not every information that the client gives you that is privileged. There are exceptions. The following are not privileged, and that is the client's name. The client's name is not privileged. Facts learned by the attorney's own senses. So this is not information that was given to you by the client. These are facts that you have learned by your own senses as an attorney. And then where statute excludes it, sometimes, there are certain things that the Act state that they are not privileged, so they are not privileged. And then documents not otherwise privileged. And then documents or information which was not given for purposes of legal advice or representation. Those documents are not privileged. I think this one is quite self-explanatory, but so far, are we together? Are we all on the same page? Please write in the chat if we are all on the same page, you are understanding things so far, or even just write in the comment section if you have any questions, and then I can just have a look at it, because I don't want this live session to be long. So you can just pop quickly into the chat box and I can just have a look at that. And then the next one is contingency fees. To my surprise, from 2019 to 2023, contingency fees were asked twice. I was actually quite surprised, but they're still worthy to be studied because they are a big deal in practice. And a contingency fee agreement, in terms of the Contingency Fees Act 66 of 1997. So it means that a contingency fee agreement is in terms of the Contingency Fees Act. And this is an agreement that an attorney, enters into with their client. This usually happens in matters where there is a monetary reward, like for example, motor vehicle accidents. Clients come to you and they don't have any money. They don't have money. They are anticipating to get money when, the road accident fund pays out, or COIDA, or whichever institution. So the client will come to you without any money and they would want you to help them with this matter. And then there are two ways that you can go about this. The first one is no win, no fee. So attorney's fee is only payable if there is a favorable outcome on the matter, right? So that's that. Or you can have an increased fee agreement. So let me go over this again so that I clear that. When you enter into a contingency fee agreement, you need to state if it is in accordance to section 2(1) subsection A, or if it is an increased fee agreement. So it can be no win, no fee, or it can be an increased fee agreement. And if it is an increased fee agreement, the attorney can charge up to double their normal fee. So not more than 100%. So you can charge double your fee or 25% of the award, whichever one is less. So you've got an increased fee agreement, right? And then it's either double or 25% of the award. So if this question were to be asked in the exam, how much would the attorney's fee be if the attorney and the client had entered into a contingency fee agreement? Now, you would know that with a contingency fee agreement, it's either double my fee or 25% of the award. Now, they'll let you know, for example, let's say your fee is 1,000 Rand. Now you will say 1,000 Rand times 2, because that's double. And then that's 2,000 Rand. That's your fee on the one hand. And then on the other hand, it says 25% of the award. Let's say the award is 1,000 Rand. And 25% of 1,000 Rand is how much? Is 250. So now you've got 2,000 Rand against against 250 Rand. Which one is lesser? It's 25% of the award, which is 250 Rand. And that means you will have to take the lesser one, which is 250 Rand. Of course, you would not be expected to work on such matters for 250 Rand, but that's just an example so you get what it is that I mean. So whichever one is less between the two, that's what the attorney must charge. And when you enter into a contingency fee agreement with a client, it must be in writing. You cannot enter into a contingency fee agreement verbally. You know that verbal agreements are allowed in our law, in our legal system, verbal agreements are allowed. But when it comes to contingency fee agreements, they need to be in writing. And I can tell you that if there's one person who will turn on you when things get hot, it's clients. Clients will agree with you verbally. And when they have received payment and you now want to take 25% of their award, they'll be like, why are you taking 25% of my award? And you'll say, but this is what we agreed on. And the client will ask you, where did I sign? Where did I agree to this? I don't remember agreeing to this. What then? And then the client runs to the legal practice counsel and they say, Shella wants to take 25% of the award that I have received. It is so unfair. And the legal practice counsel turns back and asks you, why do you want to take 25% of the client's award? And you will say, well, I'm acting in accordance with the contingency fee agreement. And the legal practice counsel will say, okay, well, let's see the agreement. Where did client sign? Where did you two agree? And you'll be there dumbfounded, like, what just happened? So you don't want to be in situations where now the legal practice counsel has to intervene because you did not have this in writing. So as an attorney, when it comes to contingency fee agreement, they must be in writing. Always back yourself up because clients will turn on you. And this is just a tip in general. When it comes to working with clients, when it comes to money, have everything in writing. Have the client sign. Have the client, write affidavits. Like, protect yourself at all costs because clients will turn on you if you have nothing in writing. Okay, so far, are we okay? Are we good? Please give me a big thumbs up so I can know that you are here. You can hear me. You are alive. That I'm not speaking to myself. Please just write something in the comment section. All right, I see. I am good. These notes are fire. That's right. Thank you so much for that. All right, we are all alive, I am guessing. None of us are sleeping. Let's go on. Oh, before I move on, I just want to say, do we have questions so far? Or are we good? I said earlier, I know I'm like repeating this for like the 100th time, but for the benefit of those that are just joining now, if I don't get through all the questions here in the chat box, please leave the questions in the comment section. This is so that everyone can benefit from the answer. So if you ask the question in the comment section and I answer, everybody else can see the answer. Or if you ask a question and somebody else adds on to the answer that I have, so we just all what's the word? We all just, just benefit from this. It just becomes like a communal thing. We all help each other. So if you don't get to ask here in the live chat, you can just leave it in the comment section and then everyone can just also contribute and benefit from the answer. So let's move on to the next thing, and that is non-legal staff. This one, okay, let me not name and shame people. But let me just tell you as an incoming attorney, when it comes to non-legal staff, please take a screenshot here, make a note, and always remember this. So the question is, may an attorney allow a secretary to consult with clients and take instructions during the attorney's absence? And the answer is the secretary or the non-legal staff may interview the client just to take formal instructions, but not to consult, discuss, or provide legal advice. This is because the client is entitled to professional advice and services which the secretary cannot provide. When a client comes to you, they come to you because they believe that you have the necessary experience and the necessary knowledge to help them in the matter that they have. So when somebody else is consulting and that person is not you, client loses confidence. Like it really makes clients feel uneasy when non-legal staff members are out here consulting with them. It's like if you go to a barber shop or a hair salon that you saw on Instagram and you saw that this hairstylist is fire, this hairstylist does the most. And you get there and somebody else starts touching your hair and cutting your hair before the actual person that you saw in the ad or on Instagram or anywhere else starts touching your hair. That's like, why am I here? That's not who I came for. I came for a specific person because you believe that that person you came for is the one that can, do your hair the way you want it to come out. So same way with clients. Clients come to you because they believe that you have the necessary expertise and knowledge to solve their problems. So don't let non-legal staff or other people take over consultations where you could do it yourself. All right. So this was not asked in the exams, but I need you to know this because you are almost, admitted as an attorney. So this is important to know. Next thing, legal practice counsel fees. This was asked in March 2023, March 2019. And the implications of not paying the LPC fees are that as an attorney, you will not be able to practice, you cannot operate a trust account, and you are not allowed to charge fees. So those are the implications. Is the screen blurry? Can we all see? Okay, I think it's back on. But can you all see the nodes? Guys, can you see the nodes? Okay, we can now see. Okay. All right, but yeah, I already said it. So sharing of fees. Now I need some interaction on this one. All right. Fastest finger on the buzzer. I need some interaction on this one. I want to see if you know, okay? Can an attorney share fees with the following persons? Can an attorney share fees with a candidate attorney? Yes, no, no explanation needed. I just need a yes or a no. Can attorney share fees with candidate attorneys? I see a no. Yes, that's correct. No, an attorney cannot share fees with a candidate attorney. With an advocate, can attorney share fees with an advocate? All right, I see a no. That's correct. Attorney cannot share fees with an advocate. I see Mapiti is asking, is the class recorded? I missed most of the parts. Yes, it is. I'm going to leave this live on YouTube so that you can watch it as many times as you need to for purposes of studying. So yes, this will be left on YouTube. I know what it's like. I remember attending this one class, and the tutor was flying through the notes, and I didn't record the session. And after the session, I just felt like, you know what, it's like I didn't even attend the class. Why can't we get these things, you know? So I'm going to leave it on YouTube for the benefit of everyone, so you can watch it over and over again, repeat it as many times as you can, so you come out stellar in the exam. So let's move on. Can an attorney share fees with an estate agent? No, that's correct. The answer is no. Okay, I see that you guys understand the sharing of fees. You know that attorneys cannot share fees. But can an attorney share fees with another attorney? Yes, that's correct. An attorney can only share fees with another attorney. And then commission based on fees for the candidate attorney, yes. But the key word is commission, not fees. Commission based on fees the attorney can give the candidate attorney. So this is just a nice incentive that most attorneys have for their candidate attorneys, for candidate attorneys to bring in clients, and then they can get, you know, a commission based on the fees that the attorney gets. All right, let's move on to the next one. Touting. Touting. Touting is soliciting work from clients and it is unethical. This was asked in August 2023, and this is the answer. So 1.1 to the question is yes, the attorney may legitimately negotiate fees with clients provided such negotiation does not constitute touting and or overreaching. Owing to the volume of work, a reduction in charges may be justified and appropriate. So this question was asking if an attorney can reduce their fees. Is it soliciting? And no, based on the scenario, when you read the question, you'll see, based on the scenario, because there's a lot of work that the client is giving the attorney, you know, like it says, owing to the volume of work, the reduction in charges is justified and appropriate. And then 1.2, on the other hand, is a different story. When the intention of an attorney to reduce fees is to attract more work, that is touting and that is unethical. So when you just reduce fees for the sake of reducing and just attracting more clients, that is unethical, because you're not reducing because of, you know, a lot of work, that you receive from the client. So that is unethical. That is touting. Touting is unprofessional. It could lead to dishonesty, and it also gives the wrong impression to the public, as they would only want to use your services because they expect a discount. Can you imagine? Because you want to attract clients, you start giving everyone a discount, and you give, let's say, 2 or 3 people a discount. Now they go around telling people how you're such an excellent attorney and your fees are so low. You can finalize a matter for 1,500 Rand from start to finish. 1,500 is all you need. Now everyone is bringing their friends, their grandmothers' friends, family friends, everyone. Everyone is coming to you because you are such an amazing attorney. And now you are left with like a large volume of work. But when you compare the remuneration that you get from it, it doesn't even make sense. So you're also acting dishonestly. You are not even using the fee structure that the Legal Practice Council wants us to use, because you just want more clients. So it leads to you being dishonest, and also you are shooting yourself in the foot. You will have an influx of clients and you won't even be making money from it. You'll be stressed out late nights, early mornings for 20,000 Rand for 20 people. So doubting is unprofessional, and it also just, you know, isn't good for you as well as an attorney, as a business person. Alrighty. Commissioner of Oaths, another big one. So as an attorney, you are automatically a commissioner of oaths. You do not apply for this. You don't have to write to the Legal Practice Council and say, hey, I have been admitted, make me a commissioner of oaths. No. So that is, you now have the responsibility of administering oaths, affirmations, declarations, certified copies of documents, and you assist the community. So there is no fee that is charged for commissioning. Do not charge clients for commissioning, not even a single rand. You are not allowed to do that. So the limitation to this, you are not allowed to administer an oath or affirmation in a matter that you have an interest in. For example, you are representing the plaintiff and you want to proceed with summary judgment, and with summary judgment there's an affidavit that needs to be commissioned. So in the affidavit, you can now be the one to commission that affidavit. That affidavit needs to be commissioned by somebody else. That's what it means, that you cannot administer an oath or affirmation in a matter that you have an interest in. You have an interest in that matter because you represent the plaintiff. And then there are exceptions to this. So these exceptions are where you can commission an affidavit in a matter that you have an interest in. And that is where there's registration in the deeds registry. And the second one is documents required to be submitted to the Minister of Justice. And then where the commissioner of oaths is not an attorney whose only interest arises out of his employment. So the third one does not apply to you as an attorney, but these are the exceptions where a person who has an interest in the matter can administer the oath or affirmation. So this was asked in March 2022, March 2021, August 2019. And the question was around the lines of, you'll see when you read the questions yourself, it was around the lines of, like, what must the attorney satisfy? Like, the attorney must be satisfied of what in order for them to commission an affidavit or administer an oath. And as an attorney, you need to satisfy yourself with the identity of the deponent. When you are, signing an affidavit, the person who is the deponent needs to come with their original identification document. So you need to satisfy yourself to the identity of the deponent. You look at the ID, you look at the person. Is this the same person? Or did some random person just take somebody else's ID and, want to commission on their behalf? So you need to satisfy yourself as to the identity of the deponent. And then as an attorney, you have to ask the deponent the following questions. Number one, whether they know and understand the content of the declaration. Number two, whether they have an objection to taking an oath or making the affirmation. Number three, whether they consider the oath to be binding on their conscience. And then thereafter, when the deponent has agreed, the deponent must sign in your presence. In your presence. I repeat, in your presence. This thing of affidavits coming, flying in, people have signed already. No, that is unethical. You have probably seen it. I've seen it. And that's not what's supposed to happen. The deponent must sign in your presence. And then after the deponent has signed, you need to certify below the deponent's signature that the deponent has acknowledged that he knows and understands the contents of the affidavit or declaration. And then you need to put the date, you need to put your signature, and then print your full names, business address, and designation. Okay, I see that a couple of more people have joined, and for the benefit of those that have joined now, I just want to say that if I'm going too fast, this live is going to be left on YouTube, so you can rewind, pause, take notes. And that's why I'm not going to be emailing out these notes, because the replay is available and then you can just pause, write, take screenshots and all of that. All right. The next one is prescription. Okay, I see a question in the chat box. It says, are we doing past papers? So I am doing the topics in accordance to how they were asked in the past paper. So like you can see here with prescription, I wrote that it was asked in March 2022, part A, question 10.1, October 2021, so that when you study prescription, you go to the past paper and you look at the question, and then you you look at the answer that I give out here on the note. So this is like revision. So just going over the specific sections by how they were asked in the past papers. That's the structure of this session. I hope that makes sense. And then prescription. Can summons be issued if the claim has prescribed? Yes or no? Okay, I see a no. Can summons be issued if the claim has prescribed? Yes or no, guys? Guys, are we sleeping? I'm seeing a no in the chat box. Can summons be issued if the claim has prescribed? I see a yes. There's a yes. There's a no. What's it? Is it yes? Is it no? So the answer is yes. Summons can be issued if the claim has prescribed. But there's a risk of prescription being raised as a defense. Prescription can only be raised as a defense by the defendant by way of a special plea only. So when the two parties are at court before the presiding officer, the defendant can't raise their hand and say, "Presiding officer, prescription has occurred," and raise that as a defense. No, that's not how it works. Prescription can only be raised by a special plea. And then the court cannot raise the defense or even point it out. Only the defendant can. So the presiding officer can't say, the presiding officer cannot say, "Oh, plaintiff, what are you doing? This matter has prescribed." No, the presiding officer cannot do that. It's only the defendant that can. And if the defendant does not raise the defense, the matter continues as though the matter did not prescribe. However, there is a risk of a cost order being granted against the plaintiff if the defendant raises prescription as a defense. So it's risky. If a client comes to you and their matter has prescribed, you as an attorney, you need to let the client know that A, your matter has prescribed, these are the options. You can either just let it go, or we can issue summons, we can do that, but there's a risk of prescription being raised as a defense, and there's also a cost order that you are risking. So you need to be upfront and honest with your client as to what happens in this situation, in these types of scenarios. So this was asked in October 2021, question 6. And like I explained, you do the following. You inform the client that the matter has prescribed. Oh, no, sorry. That's something different. So in October 2021, question 6, this is where they ask you if the matter has prescribed in your hands. So client has, asked you to institute proceedings and a matter has prescribed in your hands while you are the attorney working on the matter. What should you do? You discover that prescription has occurred. What do you do? So the first thing you do is inform the client that the matter has prescribed. You must explain it in basic terms because a layman doesn't know what prescription is. Most people know prescription as, prescription for pills. So you need to explain fully what prescription is to the client until they understand what it really is. And then the second thing you do is you advise the client to consult another attorney in order for them to assert their rights. The third thing would be don't admit liability, as this will negatively affect your claim with the legal practitioners. Oof, the legal practitioners indemnity insurance fund, that is the LPIIF. And then you inform the LPIIF of the prescription, as you are covered for professional negligence, and that includes prescription. So when a matter has prescribed in your hands, don't neglect to tell client that they have a right to consult another attorney in order to assert their rights. Don't let it be a matter of, well, this matter has prescribed, and now the client is like, in a state of shock and said that, oh, my claim has prescribed. What am I going to do now? I have no other options. No, it is your duty as an attorney to be honest with the client and let them know what they can do in this situation, and that they are, and that you advise them to consult another attorney in order for them to assert their rights. Right, marital regimes. We're on marital regimes now. We've got marriage in community of property. We know that this is the default when spouses are getting married. This is the default. If they do not have an antenuptial contract, then they will be married in community of property. This is where spouses become tied co-owners in undivided and indivisible shares of all assets and liabilities. This is the analogy that I like making with marriages in community of property. So think about when you're making a stew. You've got vegetables, you've got potatoes, onions, carrots, you've got the soup, the beans, the meat, you've got all of that. So if husband comes with meat and vegetables and the soup, he even comes with the pot, he's the one who paid for the electricity, so the electricity used to make the stew is his. And then the wife comes with an onion, and then all of that is mixed together and the stew is made. When the marriage dissolves, husband doesn't take out his meat and take out his vegetables. That's impossible. It can't happen anymore. You cannot separate a stew. If you take out the meat from the stew, you are automatically taking out the soup as well. You're automatically, you cannot separate a stew. You cannot rip it apart. So that's how it is with marriages in community of property. Now, the one who came with the onion only and the one who came with all the vegetables and all the meat now get, the shares are undivided and indivisible. So now, how do you divide the stew? This one gets half the stew, that one gets half the stew. Not just an onion, no, half the stew. That's how in community of property works. So the law adopts a two captains, one ship approach where spouses are co-owners of all the assets. So the spouses own that one part of stew, and then upon dissolution of the marriage, half a stew goes to the husband, half a stew goes to the wife, or one party and the other. So when parties are married in community of property and they want to dispose of assets or they want to get into specific contracts, the consent of the spouse is required. So there are instances where the spouses require prior written consent as well as two witnesses. So that consent needs to have an attestation of two witnesses, and that is before alienating or burdening immovable property, which forms part of the joint estate. And then the second one would be when they're entering into a surety agreement. And then where it's only written consent and two witnesses, it's before entering into an agreement of sale or donation, a loan agreement, servitude agreement, receiving credit under the NCA, and purchasing immovable property. Now, I know the 2 points sound similar, but here's the difference. The first one is where spouses require prior written consent plus two witnesses who must attest. And then the second one is written consent plus two witnesses. So there's a difference. There's prior written consent and then there's written consent. And then the next one is written consent, and then there are no witnesses needed. If you look at Section 15 and Section 17 of the Matrimonial Property Act, you will see exactly what I'm talking about. So those are the limitations, or that's where you need consent when it comes to conducting, getting into certain agreements or alienating or burdening immovable property. Just to go over this. The next marital regime is out of community of property without accrual. This is complete separation of property. A complete separation of property. Each spouse retains the estate that he or she had before the marriage, as well as everything acquired during the marriage. So each spouse has full legal capacity to enter into contracts without the consent of their spouse. What is yours, what is mine is mine. That's the approach of out of community of property without accrual. And then the spouses can enter into contract with each other because they have two separate estates that don't join together. And then we've got marriage out of community of property with accrual. So this is a delayed in community of property. I say delayed in community of property because the in community of property, like something similar to in community of property, only kicks in upon dissolution of the marriage, because accrual only happens when the marriage dissolves. So during the marriage, you can't be like, oh, accrual. No, it's only a dissolution of the marriage. And at dissolution of the marriage, the spouses must share in the growth. Very important, must share in the growth of their estate without there having been a joint estate during the subsistence of the marriage. So you share in the growth, not in the amount or the value of the assets that a spouse has at that particular time, that when the marriage dissolves. Does that make sense? Only the growth. So that's why there are calculations when it comes to accrual. And the formula for accrual is the net end value less the commencement value less the assets that don't form part of the accrual. So when you use this formula, you get to the accrual, you get to the growth that forms part of the accrual. It's not just any amount, or the amount of your assets that forms part of the accrual. No, it is the growth of the person's estate. And then there's a formula. The formula is, as you see on the screen. Now, here's an example. Again, fastest finger on the buzzer, take out your calculator. Let's do this. Let's see if you understand accrual and what it is that I've just said. Here's an example. Anna's net end value is 4 million rand, right? That's the end value. Before she got married out of community of property with accrual, her assets were valued at 1 million rand. So she started with 1 million rand. During the course of the marriage, she was involved in a motor vehicle accident. Upon learning that the award for damages sustained could be over 1 million rand, she instituted divorce proceedings so that her husband would not have a share in the award. She received an award for patrimonial damages for 1 million, 1.5 million. Due to the accident, she's unable to work and has received her pension fund of 2 million rand. What is her accrual? What is her accrual? Like you saw on the previous slide, what is the formula? The formula is the end value less commencement value less assets that don't form part of the accrual. So based on this scenario, and based on the formula. What is Anna's accrual? Let's see. Fastest finger on the buzzer. Let's see who can give us an answer. Let's see if you are understanding accrual. Let me give you like 1 minute to sort of figure it out. Don't be shy. We're all learning here. Okay, I've got 1.5 million. Is it correct? Can someone dispute the amount or can somebody agree? Is this the right one? Maputi, thank you for your answer. We've got 1.5 million. Are we understanding? Or if you're not understanding, just write in the chat box that, you know what, accrual is something that I'm not understanding right now. Go over it again. Somebody says 2 million. And Mo says 2 million. Is it 2 million? Okay, 2 more answers and I'm giving you the answer. Are you guys still figuring it out? Come on, guys, wake up. It's almost midday. It's almost midday. Let's go. What's the answer? I'm seeing 2.5 million. No, I'm even seeing a formula. Oh, let's go. Okay, let's shoot straight to the answer. All right. For the benefit of those that are not sure, let's move to the answer. All right. Here's the answer. Like I said, accrual is the net end value less commencement value, less assets that don't form part of the accrual. So we've got 4 million rand. That was the end value, less 1 million rand. Why is it less 1 million rand? Because that's her commencement value. Less 1,500,000. Why are we lessing 1,500,000? It's because I'm going to go back to the question. We are lessing 1.5 million because that's she received an award for patrimonial damages of 1.5 million. And we know that patrimonial damages are excluded from accrual. Less assets that don't form part of the accrual. And we know that she got an award for patrimonial damages. And, that is 1.5 million. So it's the commencement value less. No, sorry, the end value less commencement value less assets that don't form part of the accrual. So 4 million less 1 million, that's already 3 million, less 1.5, that is 1.5. I see 1.5 there. The others that got it right, yes, that is how you calculated. Now I want to talk about this pension fund of 2 million rand. So if you get to the exam and they ask you such a question, and they put in their amounts like pension funds, a large payout from their workplace, or they are now a contractor and they are receiving a monthly income of maybe 500,000 rand every single month. That is just to sort of like throw you off because those amounts form part of the end value. If they give you a value and that's the end value, and then they also give you an amount that forms part of accrual, you don't have to add it, you don't have to subtract it because it's already included in the end value. Does that make sense? So here, if I were to add on this scenario and say that now that she doesn't work anymore, she receives 500,000 every month because she's an artist and she draws paintings for people and people pay her that amount. That amount you wouldn't have to add it to the end value because it's already included. But what you minus, what you subtract is assets that don't form part of accrual. And that's what we're moving on to. What does not form part of the accrual? And those are assets declared in the antenuptial contract or acquired through the spouse's possession or previous possession of that asset. Secondly, amounts accrued through damages, except patrimonial damages. Let's talk about that one a little bit. So, amount accrued through damages. Wait, what does not form part of the accrual? Patrimonial damages don't form, I think this was incorrectly written. Patrimonial damages don't form part of the accrual, but special damages form part of the accrual. Okay, this is drafted correctly. So amounts accrued through damages, they form part of the accrual except if they are patrimonial damages. So let me explain. There are general damages and there are patrimonial damages, also known as special damages. So what forms part of general damages? What forms part of general damages is things like defamation of character. If you get a payout, in a defamation of character claim, it forms part of the accrual. But because a car accident is patrimonial damages, it's special damages, that does not form part of the accrual. Somebody let me know if you understand what I've just said. There's special damages and there's general damages. General damages are not patrimonial damages. General damages are things like, like I said, claims for defamation of character, and that those are general damages. And then patrimonial damages slash special damages include things like, the damage to your car, medical expenses, and those don't form part of the accrual. Donations as well, legacy and inheritances. This was asked So this was asked legacy and inheritances, donations, and that. And then this was asked in August 2022 and March 2019. So when you're studying marital regimes, just look at those questions and, just see how they were asked in the exam. But that which I've given you, this content that I've given you is sufficient to answer the questions. Just in general, the questions that I wrote that they were asked in the exam, the content that I give you is enough to answer those questions. So this is sort of like a memo, but done topically. All right, I see a question. Does money won in the lottery form part of accrual? That's a very interesting question. What do you guys think? Do you guys think money won in a lottery forms part of the accrual? Hello, guys. Do you guys think money won in the lottery, does it form part of the accrual? Okay, you guys are not sure. I would say that the lottery does not form part of accrual. I say that because look at donations, look at the nature of a donation, and look at the nature of the things that are included in accrual. It's things like an income, and the lottery is not an income. So what's included in the accrual is things like income, and I don't think that the lottery forms part of um the accrual. I do not think so. Nothing in the theory that I've just read clicks that the lottery will form part of accrual. I see here, I think it's like a donation doesn't form part of the accrual. That's what I was thinking. I was looking at donation as well, and that no, it does not form part of it. But that's a very interesting question. Hey Maputi, thank you so much for asking. That's a very interesting question. Let's just hope the the examiners don't ask it in the exam. But I think it does not form part of um accrual. All right, maintenance. We've got maintenance. We're almost at the end of the session. Maintenance. We've got maintenance. There's a legal obligation towards both parents to support the child in accordance with their respective means. Whether the parents are married or not, that is irrelevant. Obligation to pay maintenance ceases when the child is adopted or becomes self-supporting. So then we have a question that we got in August 2023. It said like, what are the factors that the presiding officer must take into account when awarding or determining an amount to award for maintenance? And that is the lifestyle and the standard of living of the child, the financial needs of the child, the income of the parents' ability or inability to pay maintenance. Both parents are liable for maintenance. So they look at that as well, that it's not just one person who's liable, it's both persons, it's both parties. And the lifestyle and standard of living of the child is not determined based on things that are not needs. Like the second point says, financial needs of the child. So wants are not assessed in this. So you cannot say that my child needs to attend concerts every month, to see Barney live, to see Spider-Man live at the mall, because the mall will have, these Spider-Man people in costumes, and now your child must go every single month. No, that's not a need. That's not a need. So those things, costs relating to that, will not be taken into account. So far, are we good? So far, are we good with maintenance? Are we all right? Are we all right with maintenance? Okay, I think we are okay, because it's self-explanatory, and also I'm going to leave this on YouTube so that you can play it back, take a screenshot, write all of that. And then we are done with the content. We are now moving on to drafting tips. These are things that I think are important to note when it comes to drafting, and that is, know the theory behind the drafting of contracts. I cannot stress this enough. When you know the theory behind anything that you're drafting, you'll be able to draft it better. Like, for example, if you know the citation of the parties and how it is in a contract, you know what is supposed to be included. You don't have to cram it. If you get to the exam and you have crammed and you forgot your keywords, it's over for you. There's no way you can recover from that. But when you know what's supposed to be included, even if you don't remember it word for word as you have studied it, but you know what's supposed to be in that clause. You know what's supposed to be in that clause, so you will put what you know is supposed to be there. It might not be word for word like, the theory that you have studied, but you will know what to include. an example that I'm always making is with Rule 18. If you're writing paper one, please, no Rule 18. Rule 18 is the rules relating to pleadings in general. And it says how pleadings should look like, what should be included in pleadings. And one of the things is that a pleading must be in paragraphs. So if you write, if you write half a page and you say it's a pleading, like you just write one big paragraph, and you say it's a pleading. No, that's not a pleading, because according to the rules, a pleading must be divided into paragraphs. A pleading must have a signature. So if you're writing a pleading there and you don't have a signature at the end, it means you don't know the theory. It means you didn't read the rule. You didn't see the rule. The rule says that a pleading must have a signature. So if your pleading doesn't have a signature, that means you don't know what you're doing. So know the theory behind the drafting of contracts, or any other agreement that you need to draft in general. And then, for example, general clauses versus special clauses. There are certain clauses that must be in each and every single contract or each and every single agreement. For example, the parties. Each and every single contract needs to state who the parties are to the contract. It needs to state their legal capacity. Are these people who are represented by executors? Are these minors who are represented by parents? Are these people with full legal capacity? You need to state these things. So these are general clauses that must be in each and every single agreement. And then there are specific clauses. Some specific clauses are specific to that particular contract that you are drafting. For example, a clause on renovations. You won't find a clause for renovations in a partnership agreement, but you will find a clause for renovations in a rental agreement. In a lease agreement, you will find those specific types of clauses. So there are general clauses, certain clauses that must be in every contract, and there are specific clauses. Usually in the exam, they will let you know that, only draft this part, maybe they will say only draft the domicilium clause, only draft the resolutive condition, and then know the theory behind, the specific contract that you are required to draft. You might know the theory behind drafting a contract, that a contract is supposed to have this, that, and that, but you also need to know what specific contracts need to have. So, example, suspensive conditions and resolutive conditions. So these suspensive conditions they suspend the operation of the agreement until the occurrence of an uncertain event. If the event occurs, the agreement doesn't come into existence. If the event does not occur, the agreement comes into existence at the date of signature. And then a resolutive condition terminates the operation of the agreement upon occurrence of an uncertain future event. If the event occurs, the agreement terminates. If the event does not take place, the agreement continues to be of full effect. Now, this might sound like a whole lot of theory. Why do I need to know this? No, you need to know this because here's an example. Garawa and Marcia conclude an agreement for the sale of immovable property described as F31 Devonshire Avenue, Bryanston. The purchase price is 900,000. The sale is conditional upon the purchaser obtaining a home loan of 750,000 rand. Draw the clauses to include in the contract. Draw, number one, the suspensive condition. So if you're writing a suspensive condition, this is what the clause will say. So do you see that if you don't know the theory behind a suspensive condition, you won't know what to write in this scenario? Am I right? Do you guys see why I say you need to know the theory? Like, do you guys get why I'm emphasizing the knowing of the theory? Yes? No? Yes, I see. Yes, true. Okay. So then, because you know what a suspensive condition is and you have that scenario, this is what you write. You write, this agreement is conditional upon the purchaser obtaining a bond for 750,000 of the purchase price being obtained from a financial institution, within 30 days from date hereof. Also, as you see, I did not write the 30 days in the example. Sometimes in the exam, they will say, write the additional facts that you think might be necessary. Or they'll give you such dates, then you obviously put them in there. It depends. And then, if the bond is not obtained, this agreement shall be null and void, and neither party shall have any claim against the other arising from this agreement. You wouldn't know how to draft this if you don't know what a suspensive condition is. And then in cases of a resolutive condition, then you write, should the purchaser be advised in writing that her application for a bond for the purchase price has been unsuccessful in obtaining the said bond within 30 days from date of signature hereof, this agreement shall terminate. Each party shall be obliged to restore to the other to the same position they were in had the agreement never been concluded. Now you know the theory, now you know what to write. Are we together? Okay. So again, I repeat, for every agreement, you are required to know how to draft the sections of the contract, because sometimes you are only required to draft certain sections and not the whole agreement. So, for example, lease agreement. These are the things that must be in lease agreement. If you are drafting the whole lease agreement, you must have the citation of the parties, the domicilium, whole agreement clause, breach, cession, improvement, maintenance, offer to purchase, offer to renew, payment of the rental, termination of lease, prohibition against subletting. You find that in the exam, they will ask you to write only the clause relating to the option to renew and the domicilium. So you need to know the sections of the contract, the specific contract that you are required to draft. So you must know all these things, because sometimes they might ask all of them, or they might ask only one. You find that they'll say in the lease agreement, write, the specific clause relating to maintenance. And you are now thinking maintenance. The only maintenance you know is child maintenance. You're already in a deficit. You are on the wrong path. So that's why you need to know the specific things that must be in specific contracts. And with this point, I want to say that when you are doing the drafting, when you're practicing the drafting for this exam, please, I beg of you, please, as you are practicing, you have the lease agreement. Go over the specific sections. Like I said, go over the specific sections. Then you will say, I know how to draft a lease agreement, so that anything that comes from lease agreement doesn't shock you. Everything that comes from lease agreement won't shock you if you study it like that. That's why I was saying in the beginning of this live that you need to divide your work into sections so you can see how much you have covered. Because if you just go from front to back, you won't know if you have covered everything or if you have mastered everything. Just because you feel confident doesn't mean you know everything. So that's why it's important to divide the work into sections so that you can track yourself. Then, this is something that was actually asked in one of the papers. Which contract must be in writing to be valid? These contracts cannot be verbal. I'm seeing Gift is saying the screen is not clear. Is the screen not clear? Let me go back to the second one. The previous one, can you guys not see the screen? Is it because the writing is small, you need to zoom? Is there anybody else experiencing this problem, or can everybody see? I'm getting it's blurry. Is anybody else experiencing this problem? How is it now? I see clearly. I think maybe the blur is due to the fact that the writing on this page is quite small. Magdalene, can you try zooming? Because I think if you zoom, you'll be able to see properly. But don't worry about, missing out and things like that. You can get the replay and watch this again. And when you get to this section, and then when you get to this section, you can just, I'm sorry, you can just zoom, pause, take screenshots, write, and all of that. I see others saying it's clear. Yeah, the writing is small. When you change the slide, it first blurry and then it clears up. Okay. All right. So those that are seeing, blurriness, I'm sorry, please just try zooming. Like I said, I'm going to leave this on YouTube so that you can watch, pause, and things like that. So we are here. The following contract must be in writing to be valid. They can't be verbal. Number one, antenuptial contract. You cannot have a verbal antenuptial contract. You do know that you can have a verbal contract of employment, right? That can be verbal, it's all right. But an antenuptial contract cannot be verbal. It needs to be in writing. A contract for alienation of land, credit transactions under the National Credit Act, a franchise agreement, a deed of suretyship, long lease of land, a learnership, and a lease of mineral rights. Now, I want to come to the learnership part. Some of you candidate attorneys are candidate attorneys, and your agreement in the beginning with your boss was verbal. Is that illegal? Before you sign that contract with the Legal Practice Council, you and your attorney get into a verbal agreement that yes, you are serving articles. You didn't sign anything. Does that mean that that act is illegal? Because it says here a learnership cannot be verbal. It has to be in writing. So when candidate attorneys they start doing articles with their principal and they don't sign anything with their principal. Is that illegal? Come on, guys, talk to me. Is it illegal? Okay, maybe you guys are tired. Let me just give you the answer. So when it comes to candidate attorney contracts, the contract that is recognized for candidate attorneys as them doing their articles is the contract that you sign with the Legal Practice Council. So you and your principal can get into a verbal agreement. For me, it was a verbal agreement as well. My principal was like, okay, you are hired, you can start. And I was like, okay, where am I signing? And she was just like, you are starting. And then she told me about the contract that I had to sign with the Legal Practice Council. So that's the contract that's important. So even if you sign a contract with your principal, and then 3 months later you sign with the Legal Practice Council, the one that's taken when your term for articles is determined is the one with the Legal Practice Council, when your articles were registered with the Legal Practice Council. All right. We are literally done, you guys. Yes, that's it. That's it for today's session. Yeah, I hope that you have found this session to be insightful. Please watch this session again. Go over these notes again. Even if you mute, go over these notes again so they can remind you. Do this with past papers as well. Like I said in the beginning, get the past papers from 2019 to 2023, and then you can see how the questions were asked, and then I give you the answers here. And yes, that is it for today's session. Does anybody else have any questions relating to paper 3? Yes, LPs are excluded from BCEA. Guys, it's true, hey. So if you are a candidate attorney and let's say you get pregnant, you fall pregnant and you are still a candidate attorney, just know that the BCEA does not cover you. So it's quite risky to sort of start a family while you're still a candidate attorney because you are, so to say, not an employee. All right. Does anybody else have any other questions? Because I'm about to end the live. And like I said earlier, please write the questions in the comment section. So when the live ends and then this thing is posted as a video, please write in the comment section so that other people can benefit from the answer as well. So when you comment in, the comment section, everyone else can answer you and everyone else can see the answer. We can all just engage. So I'm getting, was this your first session? It is very helpful. And when is the next session? So this was my first session. This was actually meant to be my first and only session. I was not planning on having another one, but I think if a lot of people are, wanting, let me know in the comment section. If people want another session, I think the next session will be based on question and answer. Because now the the time for writing board exams is near. The time is almost there. So I think just literally going over the theory, if we're meeting, for example, next week, Saturday, and we're just going over the theory, I feel like that's counterproductive. Now we should be working on what you don't understand. So I think that the next session, if there is a session, if there's a session, I'm not promising anything, but I would like to have another live session if you guys have questions, because I know what it's like. Hey, like I really know what it's like. I wrote paper 3 twice. So the first time I wrote it, I failed dismally. And then the second time I wrote, I studied like my life depended on it. That's actually what I would tell myself. I'll be like, I'm studying like my life depends on it because it really does. And I studied so hard for the paper. I prepared adequately for the paper and I came out stellar. I got a distinction for paper 3. So I know what it's like when you don't have a tutor, because I didn't have a tutor. When you don't have a tutor and it's like nobody wants to help you, nobody wants to come to your aid. And it's like you're trying to knock and there's just red tape everywhere, barriers everywhere. It can feel so overwhelming. So I really want to be that person that helps others. So I think if, a whole lot of you ask questions in the comment section, I think we can have another short live where we just deal with the specific questions that were asked. Now with the live session, it's not going to be like this. The next live session, if there's a next live session based on your questions, if there's another live session, it'll just be answering the questions that you have. Not this way, not this format. Okay. Let's see, Maputi once more. Okay, you will comment in there and then okay, another session. So another session will be dependent on the questions that I ask. The questions that you ask. So that is it, you guys, for today's session. If you have found it helpful, please, comment in the LinkedIn post, comment on here as well. And then I can see if a lot of people are interested and if a lot of people have questions that need to be addressed, urgently because you're writing in a very short period of time, then I'll do another live session. And then this time we'll just be dealing straight with questions. We'll just be answering questions and dealing with that. Is that okay? Can I end the live? Can I end the live? And then I will post in about 15 minutes. I'm not sure how the live thing works. I think it remains on YouTube. So just comment on there and then we'll take it from there. Okay, I see here. I wish we focus more on the exam guide for March 2024. Okay, since you are studying for the paper, for questions that you are not clear on and you want me to answer, like I said, questions, and then the next session will just be a Q&A, strictly Q&A. All right, I think this is it. I'm going to end the live. Thank you so much for joining. I am grateful for you guys being here because I'm honored to be the one hosting this class for you. And I hope that you do not forget that kindness goes a long way. When you are admitted, which you are going to be very soon, I hope that you also lend a hand to other candidate attorneys who need it. And yeah, those are my closing words. And maybe I will see you on the next live session, which is a Q&A. Thank you so much for joining me. And yeah, may God bless you and crown your efforts in the exam. Bye. Bye, everyone. Okay, what am I doing? I have no idea. What am I pressing? Okay. Okay, that's it. Bye, guys. I found the button. Bye.